One of the first things we deal with in an initial interview with someone that's contemplating divorce is that we suggest that they not initiate legal proceedings at that time, but rather than put the court in charge of their affairs, for them to ultimately sit down with their spouse and see if they can come to some resolution just in a conversation at the kitchen table. Sometimes that's difficult. Sometimes it provokes an argument. What I've often suggested to people is that they make an appointment to meet with their spouse, saying, look, we can't talk about this right now. Why don't you think for a day or two about what you'd like to see happen? How do you like to see this matter resolved? And maybe we can meet on Tuesday. The kids are out of the house. It's a quiet time. People sit down with a blank pad of paper, and if they resolve some issue, they simply write it down, put the pencil down, and talk again. And if they can work through their issues that way, they're going to be in control of their situation. It's going to be much, much less expensive, and the arguing and the fighting and the poking each other in the eye is going to be much less of a problem. Family law issues that we deal with really span the entire gamut of custody, visitation, divorce-related issues, child support, alimony, property division, really the entire gamut of affairs. One of the biggest issues that arise for the principal wage earner and in a household in a divorce situation has to do with not only property division, but alimony and a claim for alimony by the spouse. The spouse in Maryland can typically expect long-term alimony, but it's not based on a calculation. It's based on an 11-factor analysis done by the judge, which makes it very risky going into court with a demand against you or against that wage earner for alimony. And so the thing that we do at the law office of John P. Downs is a very careful financial analysis of both sides and both parties so that we understand those 11 factors and the analysis that the judge is going to go through in court long before we go to court. That careful financial analysis, which may also include the participation of an expert where we can analyze the wage earning potential of the other spouse to put my client in the best possible position going into court, is what we find to be the best way to approach that subject. And we begin that analysis at day one in our first interview. Maryland typically requires a 1-year separation before that person is even eligible to file for divorce. In the event of infidelity, Maryland recognizes that should the couple make an attempt to reconcile, that the spouse that has been injured can't come back and then assert the claim that they should get a divorce on the basis of that adulterous relationship. And so that spouse needs to realize that they either are going down the path of reconciliation or they're going down the path to divorce. They have to realize that as soon as they understand that their spouse has in effect had an affair. Maryland is an equitable distribution state. The courts attempt to balance the interests of the parties. It's often said it's 50-50, but it really isn't 50-50. It's sort of a starting point is 50-50. From that point, other factors weigh into the analysis. And the judge, if he or she should so decide, and based on the factors and the testimony of the parties, can make what's called a monetary award to offset the factors that have come out at trial. If you're going through family law issues such as custody, visitation, divorce, alimony, property division, please see us at the law office of John P. Downs, 410-398-0313, or go to our website, jpdownslaw.com. At the law office of John P. Downs, we offer flat fee consultations in family law matters.